Filing for bankruptcy is a serious decision that will follow your credit report for the next decade. However, making decisions to do it is the hard part. Everything else after that is fairly easy. My name is John Ross with Finance on a Budget. In this video, I'll be talking to you about how to start bankruptcy. After your lawyer organizes all the paperwork, he then files it with the court. At this point, all of your creditors are stopped dead. They get a cease and desist letter in the mail, meaning they can't call, can't write, can't nothing. All they can do is wait for the inevitable dismissal of your debt. But first, there are some online consultations and questionnaires before the dismissal of the debt, plus the actual court date. So, even after everything is collected, there's still a little bit more to do. But it's not really that big of a deal. I've been through 3 bankruptcies in the past, and I barely remember anything about them. I remember my first lawyer had these awful overhead lights that gave me a headache. The second I don't recall at all, and then the third was the same lawyer, and what I remember is having to take some dumb online seminar for about 45 minutes. All in all, it's not that bad. Please note that any IRS-related audits or other tax-related issues are not slowed down by a bankruptcy. Remember, everyone else be damned, but the US government always gets their money. Death and taxes. Please be sure to give this video a like, because that simple act will help us grow. Planning for bankruptcy. A Chapter 7 bankruptcy is basically a complete liquidation of all of your assets, if you have anything of value. After filing Chapter 7 bankruptcy, you'll receive a case number. A bankruptcy trustee is assigned to your case, and they will be in charge of overseeing your bankruptcy filing. This includes reviewing the bankruptcy forms, verifying information, and possibly conducting a meeting with your creditors. However, in today's society, it's more of a formality because none of your creditors are likely to show up. You have to attend one official meeting at least, and if issues come up, be prepared to testify in court. These issues may include clarification on whatever you disclosed in the bankruptcy paperwork that you filed. One last important thing. All of the property that you own that exceeds the value of your state's exemption laws is subject to sale by the bankruptcy trustee. If you have very little, then this is the type of bankruptcy that you want. If you actually have valuable assets that you want to keep, this falls under Chapter 13 bankruptcy. This means you will pay back most, if not all, of the debt. If you have a Chapter 13 bankruptcy, you will need to have a judge approve the proposed repayment plan that includes proof that you can afford the payments. If you miss any of the planned payments, a trustee might file a motion to dismiss your case, leaving you back at square one. You also have to be prepared for adversary proceedings, as any creditor could have a reason to file a lawsuit that challenges your right to a general discharge or the forgiveness of the debt. But since people file all the time without issue, I can only think of perhaps a local business may dispute. For example, a contractor who worked on your house. But even then, he would put a lien on the property. So I'm not really sure who would actually dispute it. So I guess it's on a business-by-business basis. Just rest assured that by the time you're wrapping up your foreclosure, credit cards and personal loans have already been sold off to third-party collection agencies. So none of the banks are going to show up, not even if you have a mortgage involved. I've done this several times, and not a single creditor ever showed up to dispute anything, because at that point, they will be throwing away good money after bad for a lawyer of their own. How can you make sure the bankruptcy process goes smoothly? The first step is always to consult with an attorney. While you can do it yourself and have a free counseling agency help, it's best that you hire an experienced lawyer who does this all day, every day. They will know what to look for. Once you do have a lawyer and get things started, complete the bankruptcy paperwork as honestly as you can and disclose what you need to in order to avoid complications down the road. These are called bankruptcy schedules, and they should identify the following. Your petition for bankruptcy, which includes a basic information about you. This part is easy. It's just your name, address, etc. Your property list, which includes all of the property that you own on the date of the case filing, along with an estimated value. This would be a house, car, boat, or anything else that conceptually could be sold off to raise funds. But if your house doesn't have any equity and you still owe or lease your car, then there's nothing of value. Your creditor list, which includes the name and address of all the creditors. This is really important because you don't want to forget anybody, not even things a decade old. You don't want anyone coming back looking up a debt that you long since thought was dead. Your budget, which includes the current monthly income and expenses including anticipated changes in incoming that exceed 10% within 1 year after filing. Here, you want to ensure that you really can't afford all that debt. You don't need to be dollar for dollar, but the idea is that you would not be able to pay back the debt within a reasonable amount of time. In the case of Chapter 13, that would be 5 years. You'll also need your statement of financial affairs, which is a questionnaire about your financial transactions over the past few months. They basically want your personal or joint bank statements. However, if your spouse is not filing with you, then their own personal bank accounts, credit cards, and assets may not be touched by the court. You also need to verify your income, usually with pay stubs. This means that you will need to provide all of your income. If you're self-employed like me, you need to provide a profit and loss statement for the past few months to prove that you have steady income, which is backed up by the bank deposits. This brings us up another topic. How do you pay a lawyer when you're at rock bottom? Lawyers cost around $1,200. I had previously suggested changing your phone number or otherwise blocking the creditor calls. So, if they are not directly interrupting your day, then you can simply ignore them for a while. No one said you had to file right away. This will give you a chance to start saving $100 a month so that you will have it ready by the time you need it. Remember, it won't be until 8 to 12 months down the road before someone actually tries to sue you in court. It's only here that you really need to take care of this. Once the judgments against you happen, that's when they can garnish $35 out of your paycheck per week or go into the bank account directly and drain everything that you have. But until that point, simply save the money that you're no longer paying your creditors. Bankruptcy is more stressful to think about than it is to actually do. The case may take 1 to 2 months from start to finish, but your personally invested time is largely spent on collecting old paperwork to pass on to the lawyer, 1 or 2 online sessions, and a morning in the courthouse. It's really not that big of a deal. Be sure to give this video a like, subscribe, and ring the notification bell. Thanks for watching.